Good afternoon. I'm Steve McAuliffe, and I've been asked to interview an eminence grise of the New Hampshire Bar, Michael Callahan, for the Bar Foundation's Oral History Project. Brief background, when I left the Attorney General's office, I was hired by Mr. Callahan after he worked very hard. I had to go through two successive full interview processes before he could drag me over the line. And then I worked for him for about 12 years as his mentee. And Mike is certainly a hero of mine and one of the best trial lawyers, obviously, in New Hampshire. He's always mentioned when if you talk about who are the best trial lawyers in New Hampshire, Mike's name always comes up for good reason. I learned most everything I know about litigation or trial work from Mike, and it is a great privilege for me to do this interview. So, Mike, why didn't you become a doctor?
First, I would say this, that what you said about being a mentee is whatever credit I've ever got for being a mentor, it was by having really smart, capable, talented mentees. So
this is going to go well.
let's vault that hurdle quickly. But why did I not become a doctor? I don't think I was good at physics, and I was okay in chemistry, but too much science was going to end my medical career quickly.
So that leads to the obvious question. If your dad was the clerk of court for the Merrimack County Superior Court where you were growing up, did that cause you to want to be a lawyer?
I don't think necessarily. I did get to go see a lot of courtroom activity, so that I had some sense of what that was like, but I wasn't particularly charmed by it. I think if I could have done anything, I would have been a sportscaster.
But your dad Henry was a good athlete, of course.
He was a good athlete.
And your Uncle Denny was a good athlete.
They were all good athletes.
And you were born in Concord, you grew up in Concord?
I'm one of the few that I was born here. I went to Concord High School here. I went to college in Connecticut, went to law school in New York, and came back here and started practicing law at the Solway Law Office.
So I understand that from our past talks that Dave Nixon, a legendary lawyer in New Hampshire, had something to do with your going to Wesleyan as opposed to Dartmouth.
I always wanted to go to Dartmouth, and Nixon and a fellow named Kimanzakis, who was a lawyer in the Sheehan office, both went to Wesleyan and convinced me that I should want to go to the Little Three. And so I went down to Amherst and Williams and Wesleyan, and the only person I met at Wesleyan was the admissions director, who was charming. I was escorted around Amherst by probably one of the few jerks at Amherst, so I didn't like that place. And similarly at Williams, and so I ended up at Wesleyan.
And then you went to Cornell.
Went to Cornell Law School.
And I understand it was Jim Muirhead, who was also a very well-known, capable litigator in New Hampshire, also went to, he was in your class or ahead of you?
He was a class ahead of me.
But younger.
I was a second-year law clerk at the McLean office during the summer between my second and third years, and Muirhead was a first-year associate. And I worked on a case and concluded that we were going to lose. And Muirhead then wrote the brief and won, so he held that over me for the rest of my life.
And you're talking about now when you were in law school, you were clerking at McLean?
I was clerking at McLean between the second and third year of law school.
And back then it was Brown, McLean.
I worked for Stanley Brown.
But who was it? It was McLean, somebody in Brown?
McLean, Carlton, Graff, Green, and Brown. Yeah. Graff represented Rockingham Park, Green represented the telephone company, and Brown was a very powerful, strong litigator.
Yeah. I think I saw Hugh.
Although Arthur Green was a great trial lawyer.
I think I saw Hugh Bounds refer to him as the best litigator he had ever seen.
I had a lot of heroes. Brown was one of them, but Ted Soden was one.
Well, I was going to ask you about Ted later, but later. You're jumping ahead here. So we're back in law school.
Yeah.
Was there anybody else in New Hampshire bar with you at Cornell?
No, not
No?
at that
Okay.
time.
So you came back and then you worked for
First worked for Soloway.
Oh, you didn't work for McLean, okay.
Yeah.
And Jack Freiberg, did he work for you there? Or work with
Freiberg
you?
worked at Soloway briefly.
Briefly, yeah, I thought he did. So
In
who
fact-
was it? Was you? Who was your class at Soloway?
It was Marty Gross and Chris Gallagher and me, and Don Gartrell.
And Freiberg for a while.
Freiberg for a while. Freiberg wrote a memo on negligent misrepresentation, which whoever he wrote it for didn't like, and I lived with it for about 20 years. It was excellent.
Now, Soloway, what did you do at Soloway? You were mostly a litigator?
I wanted to, the thing that I loved most in law school was the Uniform Commercial Code. So I would have,
Doesn't everyone?
I would have loved to play with that. Unfortunately, there was not a lot of Uniform Commercial Code work. So I ended up as a trial lawyer. I started out bagging for both Ted Soden and Larry Spellman, who were the lead trial lawyers at that time. I learned a lot from Larry about how to preserve a record for appeal, and I think I really learned how to cross-examine from Soden, who was remarkable.
For a young guy, was he hard to work for, Ted?
He was not encouraging. I'll tell a couple of brief Ted Soden stories. I wrote something incorrectly in a memo once, and back then we worked a lot at night, and I was in there at night, and I walked by his office, and he said, "Michael," and I came in, and he read the sentence that was incorrect. And he said, "Is that true?" And I said, "No." And he said, "I thought so." And that was the end of the discussion. It was time to leave. So another time, we defended a doctor who was charged with manslaughter. And there was a fellow in New Hampshire at that time named Dr. Glenn Bricker, who fashioned himself as a great medical expert. And he was an adversary of Soden's. So we tried the case, and I was there because I had tried some criminal cases. And Soden would rarely, if ever, try a criminal case, and this was a manslaughter case against the doctor. So I had 4 motions to dismiss, which I gave to Soden at the end of the case. And Soden read 2 of them. And he leaned over and he said, "Okay." And I said, "Well, if I'm going to have to write the brief, maybe you could read the other 2. And this is the introduction to the other 2 that he gave to Judge Keller. I still remember. "My young associate here, Mr. Callahan, who purports to know something about this, has asked me to read these." And with that ringing endorsement, he read them, and one of them was granted. So it worked.
You write cryptically, plainly. I know you always drill that into us at Gallagher, Callahan, and Gartrell. Did you get that from him, or was that something
Yes.
you've always?
There was no question.
Yeah.
Ted was this great as a trial lawyer. The file got smaller as he approached trial. So literally, he would be throwing things away that he found irrelevant. And he wrote the same way, very tersely, very briefly, and to the point. And I think, to this day, when you're writing for judges, hopefully you would agree with me, it's better to just tell them what you think and get it over with. And this is why I should win, and here it is, one time.
Well, I do remember when I left the Attorney General's office, I had an expansive view of writing. I liked writing, and an expansive view, and I remember that was a struggle at Gallagher. Callahan was just saying, "Yeah, that's cut that in half, and then try to cut it in half again."
I can remember saying to you that you loved adverbs for some reason, and I can remember saying that an adverb is just proof of a bad selection of a verb. So.
I remember seeing Ted Soden when I was, again, first in New Hampshire, trying cases against Jimmy Khalid I can't think who else I saw.
Joe Millimet. Joe
Millimet, and I remember thinking that he seemed brusque and curmudgeonly, was not trying to ingratiate himself in any way with the jury. And I remember his arguments always seemed to end with, there are two reasons why I win, one and two. And I always think you were not so curmudgeonly, but you always seem to have, there are two reasons why we win.
I actually saw Ted Soden try a medical malpractice case. I was, second chair. And he tried the case, and it was in Exeter. And it was a very difficult case. It was a woman. It was a difficult birth. A woman ended up having a full hysterectomy, and the baby died. It was just awful, and we were defending. And this literally was the final argument after a week and a half of trial. There are three things everybody agrees about in this case: 1, 2, 3. If those are true, we win. Thank you.
Yeah. Courage. Courage. I always tell people you always had the courage to sit down, which I never had. And, that takes too much courage to sit down. No questions. Who were the luminaries, I suppose, of the trial bar? I guess that's what you were in mostly. The characters and luminaries when you were young, like when you were an associate junior partner.
Phil Peters of Wadley. Paul Nuri of Wigan Nuri. Joe Millimet, Divine Millimet. Johnny Sheehan at Sheehan Finney. I never really saw Bill Finney try cases, but he was also in that category. And all of those people tried a lot of cases and regularly, even when they were senior partners in the firm.
Difference between then and now?
The difference is that my contemporaries all worked for one of them, and we were mentored at length. I had been to 23 depositions before I ever took one. That just doesn't happen today. So that by the time I took one, I had a sense of how that went. And Larry Spellman was particularly good about talking about it afterwards. Ted, you had to learn by watching. There was not much to discuss.
Joe Millett, you mentioned Joe Millett, reminds me. Do you ever recall, I had a conversation with you once when I was in the AG's office, and I said I was dealing with Joe Millimet on some sort of housing Section 8 financing thing. And to the extent you remember it, you might want to tell that story. Although it made me look better than I was.
You said words to the effect of, I think we were going to try a case against Millimet up in Grafton County.
Right.
And you said words to the effect that you had worked with him and you weren't very impressed. And I said, really? And I said, why's that? And you said, well, I did most of the work. And I said, well, did you read Tom Sawyer? And I think when you saw Joe try the case.
I think I remember you asking me, so in the end, he didn't do a very good job, didn't know much about it, but he got everything he wanted and you did it. Yeah. And the light went on.
I also said, I think Joe was first in his class at Dartmouth and first in
That's
his class
right.
at the Yale Law School.
Does that make a
but
difference?
They were dumb back then.
Yeah, I remember we tried that case, and Joe Milliman was up like way into the night all the time with the light on.
I remember that case because we had laid a really neat trap for Millimet. And about Wednesday, he saw the trap. And it was about Thursday before we realized he saw it because he started working his way out of it, slowly but surely. He's a brilliant, brilliant man.
Whatever happened to your contemporaries, like Jack Freiberg and Marty and Chris?
I don't know. The group of John Ross was in that group.
Oh, John Ross.
The group that I tried. Oh, Bill Orcutt was out of Wadley. All of those people were insurance defense lawyers, and that afforded you the opportunity to try a lot of cases. I said to someone once that I drew or prepared to draw a jury once 11 weeks in a row. But the cases were very short. They were 3 or 4 days. Remember, the discovery was 30 interrogatories. You might have the plaintiff's deposition, maybe the treating doctor, and you went to trial. And so you were cross-examining people that you had never deposed. And the way I learned to cross-examine was that my father said to me, try a lot of criminal cases as soon as you can, because police are experienced witnesses and they're good at not answering questions. And so I tried a large number of misdemeanor cases the first couple of years I practiced law. I almost got fired because Soloway didn't want me trying them. But it's a good way to, I don't know of any other way to learn to cross-examine than to cross-examine. Yeah. And it's a great, I don't know what you think, but I think it's a great weakness in the trial bar today.
What was Soloway like when you worked there? I mean, I have this image of a sort of a Brahmin, old 19th century cultural kind of firm.
It was called the House of Lords.
Oh, really?
And it was that. When I practiced law there from 67 to 75, and then Chris and Don and I left to form Gallagher, Callahan, and Gartrell. And that was the first time young partners had ever left a law firm in New Hampshire. It was a big, dramatic moment. It turned out to be not nearly as dramatic as everyone made it out to be. But it was something different.
Because junior partners just didn't leave big firms.
Right. The way it worked then, though, was very hierarchical. You just worked your way up the letterhead, and salary and status were pretty much tied to seniority. And so one of the tensions in law firms at that time was young lawyers were starting to feel their oats more, and we got trapped in the middle between the new young lawyers at Soloway and the old guys. So we were telling the young guys you have to wait, and the old guys you have to change. And it turned out everybody didn't like us. We just left.
Tell us about the early days of Gallagher, Callahan, and Gartrell.
Although everybody, people at Soloway, I think, thought we were going to take a lot of work away. We didn't. And so it was pretty much do whatever came in the door. And Chris had a fairly large labor practice. And for the first 2 years, I tried a bunch of labor cases before the National Labor Relations Board. And I mean, it's not a hard thing to do, and the National Labor Relations Act is not a hard act to understand. I mean, I think to be a good trial lawyer, you have to know the rules of court, and you have to know the rules of evidence, and you have to have a sense of how to arm the jury to vote for you. But that's about it. I mean, the legal issues are by and large fairly simple. I mean, people can make them incredibly complex, but in most trials there are 2 or 3 legal issues of any consequence. You know, one of the toughest things to learn is almost any question in a trial has some basis for objection. And it's a question of learning how to keep your butt on the board and not keep standing up.
I remember before I came over this afternoon, Andrea Johnstown, who was an associate and a partner at Gallagher Callahan, now our magistrate judge in the federal court, was telling me that for years after, like she meant like 10 years after she left Gallagher Callahan, she'd always call you to rehearse her closing and opening statements and closing arguments. That's a great compliment.
Well, hopefully she didn't follow my advice. Maybe she just wanted to talk about it so she could hear. One of the things about any final argument, I used to give them to the refrigerator, is you have to say it. Because if you write it out, it's okay. But if you say it, you'll hear the clangs. And I can't say that. I can't say this. And I tried very hard to never argue for more than 20 minutes. I thought that was about the longest attention span for the jurors.
I think you're right about that. Certainly after 35, you can see the glassy eyes starting to go. Now, Wright Dannenbarger, you and Wright are great friends and tried some cases together. Is he your contemporary? I guess sort of.
He was a little bit older than I was and a lot wiser and a lot more clever and wiry. Wright was, after a while, one of the interesting things about the practice of law, when I started trying cases, was there were probably 600 members of the bar, and less than 100 tried cases. So all of the judges knew all of the lawyers. I mean, occasionally a stranger would show up in the courtroom, but by and large, it was the same 100 people. So we knew how evil we all were, and it worked fine. The judges knew, the lawyers knew, we knew everybody's tricks. Occasionally someone would think of a new trick, but not much.
Now, going back 30, 40 years, just a memory I have, and you were always involved in this, in these larger cases that we had, and I don't see it much anymore. Do you tell us a little bit about the difference between now and then in terms of Mary Carter agreements and treaties and multi-party cases, and you don't see that much anymore.
There were extraordinary side deals made in all cases, and in multi-party cases, there were all kinds of conspiracies going on between various defense lawyers and the plaintiff's lawyers. And there'd be agreements like, I won't argue contributory negligence more than 7 minutes if you won't argue something else more than 5. And literally, people would
down to that detail,
timing each other in the courtroom. And there were all of those side settlement agreements with bridges and gaps and cuffs and collars and all kinds of names of things that went on. But
that's because cases, I guess, went to trial.
Then as now, most cases settled. Same thing. It's just lawyers. The thing that settled cases then was terror of the jury, terror of trial. I tried a lot of cases, and I don't ever remember not being absolutely frightened when they call the first juror's name and thinking, what the heck happens next? I can't remember this.
The old stage fright never goes away.
I had a great friend who was a wonderful trial lawyer in Connecticut, and I called him once after about 20 years, and I said, we were talking, and he said, do you still get nervous before the night before a trial? And I said, I'm terrified. I can't even describe how frightened I am of that prospect. And he said, not me. I said, really? How'd you get over it? And he said, well, now when I throw up, I don't get any on my suit. And so I think, and I talked to a very good criminal defense lawyer in New Hampshire once, and I said, why do we keep doing this? And he said, we're adrenaline junkies. And I think that's true. It's one of the last of the real competitive blood sports. And one of the things I find sad about young lawyers is they often come and say, the other lawyer is being unfair to me, or is bothering me, or isn't cooperative. And I said, that's their job. And I think, John Broderick and I, who went toe-to-toe, guys like that, we all understood that was our job. And we became very good friends.
You've reminded me again about a letter you got in some case. I don't remember the case, but it was a long, typical CYA sort of a letter from an opposing lawyer that went on for pages, making representations about what was agreed upon and all that. Do you recall that? And your response was like one line.
I don't agree with you.
Tell us a little bit about the difference between the bench back when you were practicing as a young partner and now.
It was a very odd relationship.
Back then?
Back then, it was, you have to remember, all the judges had seen my act 1,000 times. So they pretty much knew who I was and what I was likely to do, and what they would tolerate and what they would prefer not to tolerate, and what I would prefer to see if I could blow by them. So that relationship was, I wouldn't call it super friendly, but it was, lawyers would cover for judges when they screwed up, and judges would sometimes cover for lawyers. So it was much more collegial, I think, in some ways, simply because we knew each other and we knew what we could get away with and what we couldn't, depending on the judge. And like all relationships, those would go up and down.
Yeah.
They would like you for a while, or you would like them, and then other times not so friendly. But it was very personal.
I understand when back then when you'd try a case in co-os or something, you'd go up and stay there, and you were saying that the lawyers and judges were very friendly with each other, at least socialized, which wouldn't happen now.
I can remember trying a death case in co-os, and so the plaintiff's lawyer was from, I think, Plymouth or somewhere south of Coos County. And we were all staying at the Town and Country Motor Inn, and we would have dinner together at night. The judge,
Yeah.
plaintiff's lawyer, defense lawyer. Nobody else was talking to us, so we might as well, and it happened.
Yeah.
Now,
Nothing was thought of that as.
not even a hint of a thought.
Yeah.
And the case was not discussed. I mean, people wouldn't believe that, but you know, the judge was a big hunter and fisherman, and I don't hunt and I don't fish, and we spent an inordinate amount of time talking about something I was not interested in.
Who were the characters back then? You know, a lot of people always say, you know, it might be just a function of age, of course, but say back when we were young in the bar, there were characters in the bar and characters on the bench, whereas nowadays we don't see so many colorful characters. Who were some of the real characters back then?
There was a lot of alcohol. So if you went to a bar meeting, I mean, bar meetings now, people bring their children. You'd have to think about bringing your wife back then. It was a rough crowd, and there was, and they didn't like each other, some of them. There was Stanley Brown didn't like Ted Soden. Ted Soden didn't like Stanley Brown. Shane Devine would always try to be a mediator. And they were groups of people that were warring factions in various ways. And they were wild guys. They were. Stanley Brown punched out a state trooper, and you bound
As a lawyer.
Stanley Brown, the lawyer, punched out a state trooper, and the state trooper punched out Stanley Brown.
Over.
And you Bounds represented them, Brown, and I think it's on one of these oral history things that he defended Brown and lost at trial, that probably because when Brown showed what he did to the state trooper, he ripped off the prosecutor's shirt in front of the jury, which didn't help Eubanks' defense of Stanley. But it was a rough crowd. Not to say they weren't incredibly smart. And then the people that I really learned the most from were Don Dufresne and Mike McDonough, who Don Dufresne was, I think, the best trial lawyer in New Hampshire at that time. He's absolutely brilliant and had a very common approach and a very common touch that hid how brilliant he was. But he was something. And McDonough was just remarkable. And he combined, he sort of was almost pious in the courtroom. He was just holier than everybody else there. And under that was this incredibly dark black humor that no juror would ever see. So there were plenty of good lawyers to learn from. And I think, and they would help you in some ways. I remember the first time I went to a difficult deposition, I was a co-defendant with Mike McDonough, and McDonough did a very nice job of cross-examining the plaintiff and unfurling a variety of defense issues. And we took a break, and I was really ready to go and follow up on all of those great moments that Mike had created. And he said a very simple thing to me: don't ask any questions. And he was right, and I didn't. So I didn't ruffle the triumphs. But you had to learn. Those are the things you learned. And learning to I mean, as you know, I've tried to teach people to cross-examine at length. I don't think you can. I mean, you can within certain limits, but the best questions you can ask on cross-examination are questions that have no good answer, because it doesn't look like you're trying to control the witness. But no matter what the witness answers, it's not going to be good for them. And those are the questions that I think are the best.
What about at your firm, today's young lawyers, young litigators? What do you see as material differences?
I think they could be wonderful. They just don't have an opportunity to get knocked around. I mean, the only way you get to be a good trial lawyer is resilience. I mean, a trial is a series of bad moments, and how you deal with those and how you handle them is, I'll give you a good example. One of the last cases that I tried, the judge granted a motion in limine just before we drew the jury. So there were 3 key pieces of evidence that the judge said we could not put in. And and I just sat there. I was just sitting there like this. And the associate said, you know, we're in deep trouble. I can't imagine what we're going to do. And she said, and I was just sitting there. And she said, what are you doing? And I said, figuring out how I'm going to get them in. And as happens in a trial, doors open and in it goes. So, I mean, I think you don't learn the resilience, and you don't learn the first ruling is not the ultimate ruling.
I'm sorry to hear you say that.
Well, you judges always preserve that option. You know, I'm not going to grant the motion now, but we'll see where we are in the evidence.
Is it because there aren't small enough trials to go to trial, or it's just too expensive to try cases?
I think, well, when I first started, that was the beginning of the billable hour, and the billable hour took the middle class out of the courtroom, in my view.
How did billing work when you first started practicing?
You bill based on the amount in dispute and the sort of the level of effort. So if you were
very subjective, or negotiated, or just dictated?
They just send the bill.
You just send the bill.
But if you're in a $5,000 case, you wouldn't send a $6,000 bill.
Right. But you'd take the case. Law firms took those cases, even though they must have been economic losers?
Well, when I first had a bunch of cases, I represented insurance companies, so those were straight by the hour efforts. And then I started to represent, as you know, self-insureds, or they were self-insured with a very high deductible, or insured with a high deductible. So those were always pretty simple hourly cases. Plaintiffs, lawyers, I mean, I can remember when I first started settling cases for $3,500 and those sorts of numbers. Plaintiffs' cases, automobile accidents.
And just bill as a
soft
percentage,
tissue. Well,
obviously.
soft tissue neck, which is a fairly standard kind of automobile accident injury, was a $3,500 case. You know, maybe $5,000, but death cases. 50,000, whatever.
Have you noticed a difference from when you were a young partner to now in client approaches, client attitudes towards litigation or legal disputes?
I think clients are aggressive consumers.
Today?
They can go on the internet, they can learn about billing and that sort of thing, and they're aggressive about all of those issues, I think. And I think people are much more unhappy with all manner. To me, if I looked at what's made the practice of law what it is today, it's the issue of anonymity. If you look at the internet, people who are anonymous can be incredibly cruel and mean to other people, and lawyers who will only see each other once can be uncivilized and incredibly cruel and devious to each other. So that anonymity has changed the practice of law. That, coupled with a general dislike of lawyers and the judicial system itself. I don't think judges are as disliked as lawyers, but you're getting there. When you look at numbers of approval of the judicial system, they go down. Of course, the legislature goes down further, executive branch goes down further, but we're all going down. And I don't know what that is, but the Gallup polls, those kinds of things all show people think less of us.
How about just operating in the law firm, administrative-wise? Compare that when you were first started a young partner to now.
I think the biggest difference was one of the key items of budgeting, say 30 years ago, was staff, and now it's computers. Most young lawyers have little need for a secretary, a traditional legal secretary. So you have probably 4 or 5 lawyers and 1 secretary. As when I started, there were lawyers that had 2 secretaries and a paralegal. So that staffing part of the budget has gone away. The young people are much more concerned about lifestyle choices than when I first went to work at Soloway, we worked Monday, Tuesday, Wednesday, Thursday night. Friday night was a night off, took depositions on Saturday, and worked Sunday night. So
depositions were routinely done on Saturdays?
They were.
Why? Because everybody was
available? It was a non-trial day.
Because it was a non-trial day. Oh, sure.
I mean, a lot of time was either you were arguing motions in court or arguing in the Supreme Court, or you were arguing about something somewhere most of the time.
When did the horseless carriage come into your practice, and did it change your life?
The horseless carriage?
Yes.
Yeah, I was never a good rider.
1967 doesn't seem that far back to me.
To you.
But I guess it is. But I guess it is.
It is incredibly far back. It's so much. I think the young lawyers they don't write as well, would be one thing I would say. And the reason they don't write as well, I believe you learn to write in high school and college. If you haven't learned by then, law school is an awfully bad place to learn to write. You're now in all of that boilerplate, and you're a young person and you want to sound lawyerly, and so you start using words like heretofore and other charming words that mean nothing to anybody. I think when you hire a young lawyer who's a good writer, that's wonderful.
I just forgot what I was going to ask you. It was about starting a firm. When you guys started a firm, that was sort of a brave new world, right? Unknown kind of thing to do. How about now? I see a lot of what seem to be young practitioners that just come out of law school and open a firm. I assume that wasn't really done back then?
It was, but usually people worked for somebody when they started. And whoever that somebody was, they would break up, and that's how you ended up with 2 individual practitioners. But I mean, if I looked at some examples of things that I really saw as making a big difference in New Hampshire practice, the public defender changed the defense of poor misdemeanor defendants. I think that the felons if it was a bad enough felony, usually has some pretty reasonably capable court-appointed lawyer who was working for some lesser dollar amount. But the fellows and women who were charged with misdemeanors got the bottom of the bar. And so they used to do what I call plead them guilty and say he's not a bad boy. And they would get some lesser amount of money. With the public defender's office, you suddenly had Miranda and search and seizure, and issues were really being raised that those people never had raised on their behalf before. So that was a force for good in New Hampshire that I thought was wonderful, because it took the heat off me, because I was defending these guys. And when you raised Miranda or some search and seizure, that was just pure evil deviltry that should not be practiced anywhere. And I can remember going to a probable cause hearing in a small town with a lay judge. And I sat there for 2 hours. There were 3 defendants. And I sat there for 2 hours, and my defendant's name was never mentioned. There was never even a mention of how many people supposedly were involved in the burglary. There was nothing that related to my defendant. And when I stood up and moved for a finding of no probable cause, the judge said, "We heard about your tricks before, and we're not going to put up with them here."
Did you ever try any cases before a lay judge? We had lay judges in New Hampshire.
I did.
Markedly different? Hopefully say yes.
Yeah, very different. I tried a case sort of in a middle northern town that had a lay judge, and they had no expert to testify that the substance was marijuana. And about a month before that case, there was a Supreme Court case requiring an expert. And so I sat there happily, and they put in their case, and I stood up and moved to dismiss and cited this case that had been decided about a month before. And the judge looked at it and said to me, "That case is in the New Hampshire Supreme Court. This is the blah, blah district court. We have different laws." And I lost. I appealed and prevailed in the Superior Court, but that's a good example of what it was like.
This is kind of a minor question, but you can't help it. No, I mention it because Justice Souter, of course, is in our building, and he always looks with great disapproval if he catches any of us coming to work. Well, we don't have a hearing or trial or court appearance with an open shirt like you have on now.
Justice Souter wears a tie to grocery shop.
Yes, he does. Yes, he does. But of course, there's been a real change. I mean, compare when you never, I assume, would have thought about going to the office, even if you weren't going to court, without a tie on.
Oh, absolutely not. Yeah, that would not have happened. I don't know when that started, but I didn't start it.
But now, around the law firms, you see, if people aren't going to court, they're pretty casually dressed, aren't they?
People go and dungarees. I mean, it's the whole.
How does that work with clients? Do young associates and young partners meet with clients
that way?
Casually dressed?
They do.
They do, and the firms, and there's no pushback from the law firms anymore.
Not anymore.
Yeah, it's interesting.
And if someone like me pushed back, it's just an old man.
Old Mr. Callahan.
Old Mr. Callahan, yeah. I think one of the hardest things about growing old is, one of the things that's happened to me is I look back on all of the mistakes that I made. So I'm incredibly aware of my fallibility. I mean, things like, I remember when they put the traffic circle up by Dewey School, and I thought that was awful. I love the traffic circle by Dewey School. They're going to fix Main Street. I thought, what a waste of money. I love what they did to Main Street. So I'm not unmindful of the fact that just my personality, my raw skepticism, my pessimism makes me wrong a lot. And when you start to realize you're wrong a lot, your whole view of life is more humorous because you just realize, oh yeah, I'm wrong again. So that when I talk about the law, I'm hesitant to say, I think we're going down a bad road. But I think I'll tell you some bad roads I think we went down. I think the judiciary has abandoned a lot of the work it should be doing. Its deference to arbitration has meant that business just doesn't regard the federal court as a good place to go. It's better to go to arbitration, and the courts have said, yeah, we don't want to do that anymore. Well, they should.
For the record, the Supreme Court has said
Yes, absolutely. Heaven knows, not the federal district court. But I think that's one good example of the court deferring. I think another good example is that we have fewer and fewer jury trials. And in my view, the jury trial is the one public relations move that the courts could have to make the citizenry appreciate what they do. And so if they're not in there, if they're not getting to participate, that's another good example. And the federal courts have deferred to bureaucratic decision-making in the same way. And we've allowed the bureaucracy to supplant the judiciary in all kinds of places by deferral. And those things all sadden me because obviously the judicial branch of government has very little weaponry to start with. It doesn't have an army and it doesn't have a budget. They have a few things. They could fight for at least the land they have, and they seem to have abandoned it. Awful to say, but my view of...
processing. What about the expansion of the bar? I had to get on the bar website today, and I didn't know my bar number, but I found it. It was 1625 or something. And I think do I understand we're up 6,000 members or something like that?
And about 2,000 of them are out of state. So if you want to talk about anonymity, look at those numbers. And on top of that, the bar is another bureaucracy that has grown, in my view. I think the dues are now around $600 or something. And they're proud of all the services they render, but I don't know.
I assume you have the same experience I tend to. You go to social meetings of lawyers, and it's not the 20, 30-year-olds that I don't know, it's the 40-year-olds I don't know. Sometimes the 50-year-olds is,
of course,
again, a sign of normal aging, I'm sure.
It's just growing old. And I mean, I go into the office, they come into my office, I tell them what I think they should do. They ignore me, we're all happy. So,
I'm sure they don't ignore you.
And we go on. And so that's a lot of fun for me to interact with young people, and I'm privileged to have that opportunity. I think the idea of being fully retired for people who are doing if you're doing something interesting, don't. If you're trying to unload trucks, and have a sore back and bad knees, that's a different thing. I'm very privileged and blessed that I get to go pretend that I can think the way they think and as fast as they think. So I like that a lot. You have the same opportunity to
I'm very fortunate
do exactly the same thing.
How do clients react to the aging of the named partners? Do you find they still want your hand on it?
I don't think so. I think
it's an easy transition. I would think it would be a difficult one.
What happens in the law is when you start out practicing law and you know a lot of young professionals, they're not yet the decision makers. But as you grow older and they grow older, your peers are now the decision makers and they pick you. But
I see.
And then you grow out of that, and the new decision makers are picking their peers.
Yeah.
I think we all have a prejudice in favor. For instance, you and I think old people are still smart. A lot of people don't think that's true.
Yeah. That's interesting. The bar association meetings, you touched on a little bit earlier, but they're quite different now, the summer bar meetings, I gather.
The bar meetings then were...
Because when I first joined the firm as an associate, the firm sent me and my family.
Right.
On the firm. I'm not sure that's being done now.
It may not be. I think the bar meetings were a chance for petulant friends to make up for the sins of the prior 6 months. So there were opportunities to play golf or interact in some way with people that basically hated your guts for something that had happened during that time period. So it was a very different, the purpose of the bar meeting was not to learn, the purpose was to socialize. I mean, they would have various kinds of seminars, but the older trial lawyers would not be at them. They would be on the golf course.
I'd be remiss, since we probably don't have a lot of time left, but I'd be remiss if I didn't bring up the fact that you are the architect of the unwilling, reluctant architect of the notion that in New Hampshire, high school athletes have a property interest in their right to play interscholastic sports. How do you feel about that decision? The NHIA v. Duffley. Or Duffley v.
Let me just say
NHIA.
that decision was the product of our failure to afford due process to young Mr. Duffley. And the Supreme Court decided that case without allowing us to argue it or brief it, which are two traditional opportunities to be heard. So I'm a little bitter about it. The motion to reconsider was more of an assault than an effort at persuasion. And here we are. It's the only case in the United States that stands for that proposition, and it's not the United States Constitution that did it, but our own.
Of course, you were the NHIA's...
Who's bitter, though?
Yeah, who's bitter? You were the NHIA's lawyer for a long time, and of course they had a lot of very interesting cases, didn't they?
Well, you won, I think, one of the most important ones, that boys could not play field hockey on girls' teams. And if you talk to elite female athletes, they have no thought that they could compete with male athletes in a variety of sports. It has to do with a lot of physiological differences. There might be one young woman that could, but by and large, no, because of pelvic girdle or whatever. There's just a lot of reasons why women can't run as fast as men. And to date, they're always about a second behind in the 100. That reality does not means that we should promote more and more women playing sports. And I had a daughter who was a very aggressive athlete. Everybody said it, everything I did for women was because of her. But I think you and I both fought hard to encourage females in sports. And when I started, if a young woman was good in sports, they would say she played like a boy. And when we finished, they would say she played like some other young woman who came before
Tara Mounsey
and was a great athlete. So I always said those women got to stand on the shoulders of women who had been before them. I think it's the best thing you and I did in representing the NHIA. And I mean, I fought hard to, after the Brown University case, we really had a platform that we could hit people over the head with. And that worked. I thought it worked well, and I think women in sports continue to do well. Not as well as they should, but it's much better. I mean, when I went to school, this is my favorite story. I convinced there was a ski jump at Snow Pond, and the high school jumped on that jump. And this young woman, who was a pal of mine, was a good skier, and I said, you ought to go off the jump, which she did, and jumped a few times. And they brought us into the school nurse's office to say that I never should have let her do that because she might have trouble having children. So that some theory that her innards would get juggled by going off a ski jump. And that's where we were in sports when I went to high school.
At Concord High.
Concord High. And the woman had 3 children, just so you know.
Oh, good. Oh, good. So you don't have to wear that one. What are your, we have probably just a few minutes. What was your most interesting, fun piece of litigation?
I think the case you and I had with Wright and Muirhead and the Sheehan office, the Black Clawson.
Black Clawson.
Yeah, that was, I forget how many depositions we took, but close to 100, I think. And it was just, it was an I can remember once we were going to court, and I said to you on the way, if he does this, we'll do that, but if we do this, they'll do that. And we were predicting all of that. And I remember when we were coming back, you said, until you see it, you don't believe it.
Yeah, you were actually right, Dannenberg. I don't mean to, it's not personal, right? You were predicting that Wright, and you had an agreement that Wright would not argue something that would reflect badly on our client, Black Clawson. And you were predicting that he may not adhere to that agreement. And I was saying, of course he would. And he didn't. And I was stunned. And I remember I was arguing that point. I tried to argue against it. And I remember you sort of dragging me back down into the seat to not just let it go. And I was thinking, how could you let it go? But then it turned out there was a reason. I can't remember what it was, but there was a reason. That was the day Bill Green of She and Finney came up to argue. And Jim Shirley just about tackled him.
Yeah. It is, the hardest thing to learn in trial law is not doing things. And I think you know that there's a tendency to react to everything in the courtroom. And you can't and you shouldn't. You should only react to that which is important. And sometimes things that seem to hurt a lot, they're just unimportant. In the final argument, they're just out there on the
Well,
sides.
I remember that was something else you taught me that I was very valuable, was the first thing you do in a case is write your final argument. Mm-hmm. And work from there.
It's funny how much different it is when you get up to give it than when you started. It's a good start.
All right, what haven't I not asked you about that I should? They did have cars in '67.
Not a thing.
Not a thing?
It's a full and complete interview. Congratulations.
Well, it was a privilege. It was a privilege to be able to interview you for this.